Okay, everybody, welcome. It's great to see you all here. My name is Daniel Canstrom. As a professor here at DC and as faculty director of the Rappaport Center for Law and Public Policy, it is my great pleasure to welcome you to this first event of our spring semester. Before we begin with the program, I just want to take a moment to welcome our new and completely fantastic executive director, Amanda Teo, who we have no doubt will carry forward the great work undertaken by Alisha Medvedow. It's really an honor and a pleasure for me personally to work with Amanda. And in my official capacity and in my personal capacity, I'm extremely optimistic about placing much of the future of our center in her capable hands. I hope that many of you have already had a chance to meet Amanda, or at least to read about her on the Rappaport Center website. She's had a distinguished legal career already, and to my mind, is the absolutely perfect fit for this challenging, but we hope inspiring and joyful job. So let's take a moment just to welcome Amanda. I also want to take a moment to thank publicly our dedicated and stalwart administrative assistant, Abby Chingo, who has worked tirelessly and effectively and efficiently during the transition period and has helped to make the whole process of getting a new executive director, which is a big deal. She's helped to make it seamless and welcoming. So thank you. My main role today is to welcome you all to this first encounter with our new esteemed senior fellow, Hema Sarang-Sieminski. And we hope you know by now, but many of you probably don't, the Rappaport Senior Fellows Program has been an essential and actually wonderfully successful component of our center now since 2020, even though it feels like a new initiative to me. The initial idea was to enhance the center's work, which focuses on the most important contemporary issues of law and public policy, and seeks to nurture, recruit, inspire, develop, and support a cohort of fellows, many of whom have gone on to highly distinguished careers in public service. And we hope that we help them to do that with great appreciation for the difficulties of it, but the rewards of it, the ethical challenges of that kind of work. To these ends, we offer a highly competitive and quite excellent fellowship program over the summer. We host many conferences and symposia. We invite a distinguished professor to DC for a semester, a cohort that most recently has included Jeffrey Robinson, the director of the Who We Are Project, former Senator Doug Jones, Richard Cordray, the first director of the Consumer Financial Protection Bureau, who's also coming back this semester, by the way, and former governors of Massachusetts, Connecticut, and Maryland, Jane Swift, Daniel Malloy, and Martin O'Malley, former SJC Justices Robert Porty and Geraldine Hines, and former U.S. Attorney Carmen Ortiz. Now, the idea behind the Senior Fellows Program was to enhance this invitation list by inviting a diverse cohort of exciting, successful mid-career professionals, including academics, practitioners, and activists who work on the cutting edges of issues of law and public policy. We invite them to come here for a very intense, but point of phrase, brief and spectacular visit in which we learn from them and they get to know us, especially our students, with whom we hope they will work and develop future professional relationships and perhaps research projects. So that is an open invitation to students to engage not only with our center, not only with me and Amanda and Abby, but with our senior fellows. That's a main part of the reason why they're here. Our most recent senior fellows before today were Jean-Pierre Nadeau, Counsel and Impact Manager, head of the Defending Against Authoritarian Threats team of Project Democracy. Elizabeth Jean-Pierre, an attorney and environmental and climate justice leader who's the executive director of Uprose, Brooklyn's oldest Latino community-based organization. We also hosted senior Boston Globe opinion writer and columnist Kimberly Atkins-Storr, who, by the way, just today published an excellent op-ed on the Trump administration's attempt to eliminate constitutional birthright citizenship, which I commend to your reading. And we were also honored to host Danielle Kinkle, General Counsel of Massachusetts Housing Partnership, and Chesa Boudin, the former District Attorney of San Francisco. In this very strong tradition, we are honored and thrilled today to introduce this spring's Senior Fellow, Hema Sarang-Sieminski, who I should note has generously participated in Rappaport Center programming for today, and therefore who is already a treasured member of our extended community. Hema is widely recognized as one of the leading figures in Massachusetts legal circles in the challenging and incredibly compelling arenas of sexual assault and so-called domestic violence. As the executive director of Jane Doe, Inc., the Massachusetts Coalition Against Sexual Assault and Domestic Violence, she has directed strategic legislative and system change efforts and led efforts to shift the field's reliance on criminal legal and other punitive systems. Through a variety of work in this field for over 20 years, Hema has dedicated her career to creating opportunities for wholeness and dignity for survivors and their communities, and is committed to approaches to ending sexual violence that address and challenge the intersections of various forms of oppression. Her talk today is entitled "From Coercive Control to Collective Liberation, Stewarding the Long Arc of the Movement to End Sexual and Domestic Violence." It will be recorded, I must mention, and will be followed by a Q&A session, which will also be recorded, in which we will give priority to students, but which is open to all. I should also mention that there are students here from our 1L Human Rights class, and they are tasked with considering the subjects today, both as questions of Massachusetts and US law, but also in the evolving frames of international human rights and refugee law. Finally, please note that we're also presenting a panel presentation with Hema as a moderator and a stellar panel of experts and advocates next Wednesday, January 29th, in this room, same time, in person and virtual. And if you want more free food, RSVP, again, that's what RSVP stands for in French. Please give me free food. It's entitled "Second Look Laws and Other Emerging Issues in Domestic Violence and Sexual Assault Survivor Advocacy." Please also do check our website, as we'll have an amazing array of further programming this spring. But now, please join me in welcoming our newest senior fellow, Hema Sarang-Sieminski.
Thank you so much. Oh, it's so wonderful to be with all of you. Thank you so much for that warm introduction. And just echoing much of the gratitude to Alisha Medvedow for really ushering this program into the meeting, and for Amanda Teo for your leadership, and Abby Chengo for all that you've done to make this possible today. It is such an honor to be here. It's really wonderful to be back in a law school setting with you all today, as we have so many challenges ahead of us. I do look forward to more times to meeting with you all, and I'm told that the QR codes there are opportunities for us to be in more informal conversation throughout this week and next week, and looking forward to that. So before I begin, I want to bring in the ancestors past and present here, and really want to note that I stand on the shoulders of so many who have really committed to creating a world free of violence in our communities. And this work is carried forward by generations of organizers, of activists, lawyers, scholars. And it's important to name these folks who influenced my work and my life. So I want to just bring their names into the room. Some of them include Gloria Anzaldúa, Audre Lorde, Bell Hooks, Fergus Vade, Sue Ossoff, Beth Ritchie, Mimi Kim, Sujata Balaga, Amita Swadin, and so many more. Their wisdom and ongoing commitment to this work, it continues to inspire me and all of us today. So I am a student of a practitioner named Norma Wong. She is a Zen Buddhist monk and also a former state legislator in Hawaii. She's a movement strategist and a visionary who really invites us into the work of what she and many before her have called the long arc of the movement for social justice. But it's really the work of building the world we want to see. And, I don't need to say more than once, but this conversation comes at a uniquely striking time in our country and world for survivors and for all communities who are most vulnerable to state violence. But I want to be clear that the themes that I'm going to uplift today really transcend party politics or who's in office right now. Norma Wong has said for some time over the past few years that I've been following her work. She talks about, she'll tell audiences in this really abrupt way, a small statured person who will say, just acknowledge that we're in a point of collapse. And everyone will take a deep breath and kind of have that moment of confronting what feels like an apocalypse of sorts. And she'll say, okay, take your breaths and move on. And I think while those are startling moments, it is really a necessary reminder that we have work to do, that we can take the space we need for grief, feel our feelings as we must, and then begin the necessary preparations to take care of the immediate needs of our communities, while also keeping our eyes really fixed on the horizon of what we want to see in our world. I think this feels very tangible this week in particular, as we see executive orders rolling in. And I want us to remember that as attorneys and advocates, we must maintain a vision of what is not only possible, but what actually must be to create a world where generations to come can not only survive, but truly thrive. Our strategy must be one that allows us to effectively respond to the most pressing crises of our communities that will become increasingly unwell, that is clear, while we also keep our spirits and eyes on the horizon of a world we want to build. So that's our collective challenge today. And I want to bring in a mentor of mine, Nan Stoops from the Washington State Coalition, gifted me with this little figurine of a bison. And there's something that we can learn about the natural world and emulate. So when there's a storm, bison will line up in formation and walk through storms head first. And they do that because they know when they do that together, they will move through the storm more quickly, shelter those who come behind them, and survive as a collective. And so I think there's a lot to be learned from that. We need to do the same. We need to identify our comrades and get into formation and move through what are going to be many storms ahead. And so I just want to sit with that as a group as we come into this conversation today. So I'll share a little bit about me and my journey. I come to this work as a survivor, as an advocate, as a queer woman of color, and I've spent over 20 years supporting immigrant survivors, primarily of gender-based violence. And most recently, in January of 2020, I joined JDI, Jane Doe Inc., the Massachusetts Coalition Against Sexual Assaults and Domestic Violence, first as policy director, and then as of 4 months ago as executive director. And just to talk a little bit about coalition, since that might be a newer configuration for folks to understand, every state has a federally designated coalition, and it's really a convening body of direct service providers across the state. So in Massachusetts, we have over 60 member programs who do the day-to-day work of supporting survivors through shelter, rape crisis centers, hotlines, and other forms of advocacy. And what we do as JDI is we are sort of the policy, education, and capacity building arm of the field or movement. We provide thought leadership on where we have been, where we need to go, and what change we want to create. Just overall, in reflecting on my journey and the work of what it means to be in this field, every survivor I've ever represented and every community partnership I've helped to steward has really taught me something unique about what helps and what heals and what hinders when offering support and advocacy. And really what we need to be doing to support transformation of systems towards a world where we can believe survivors, where we can commit to survivor-led healing and justice, and share in the collective work of accountability and repair and policy creation that really emulates that. So I'd like, I'm gonna move to a bit of a history. You're gonna bear with me for about 10 or 15 minutes of history, because we're in a moment where there is a deep desire to erase history. And it is necessary for us to dive into the history of this field and movement, because it really shapes how we situate ourselves in our policy creation and strategy going forward. But I have to start with kind of an overview of the dynamics of domestic violence and sexual assault, which may be familiar to many of you, but I want us to listen to this particular conversation through a lens of how state violence and interpersonal violence really intersect. So for those less familiar with a general framework for understanding domestic violence or intimate partner violence and sexual assault, or even perhaps those who are, at the core of intimate violence as a whole is really power and control. So whether we're talking about rape or sexual assault in the intimate or non-intimate partner context, or the dynamics of abuse within an intimate partner relationship, we see patterns of power and control by one person over another emerge. So this power and control must be understood through a framework of oppression. And what's oppression? It's the non-consensual use of power by one person or entity over another to take resources that include time, energy, money, land, natural resources. It's essentially a taking for the benefit of one group or individual at the expense of another. So those oppressive ideologies, forward to do this, don't worry if you can't see this longer. So those oppressive ideologies are the ideas or beliefs that one group is superior to another. That cis is superior to trans, that men are stronger, better, more intelligent than women, the supremacy of whiteness or able-bodiedness. We can shorthand all of this into the isms for convenience. All of these isms, these ideologies are infused into our institutions and really founded and created upon these ideologies. And they're carried out in our institutions by those who are able to rise to power in those spaces. And so those institutions like courts, like law enforcement, social service agencies, healthcare institutions, educational institutions, they can often reinforce these ideologies. And we see that in policing practices that target Black men, judges that fundamentally disbelieve rape survivors, and of course, right now, the widespread adoption of anti-trans and anti-immigrant policy and legislation. And we see this over and over again. And so as people, as individuals who are so influenced by and really kind of in the water of these institutions, and these ideologies, of course, show up in our interpersonal interactions. So it can show up as interpersonal as anti-trans behavior, racist behavior, other forms of hate violence. And it can also show up as rape, as domestic violence, again, with tactics of power and control that include physical harm, threats of violence, threats to take away kids, isolation, the use of citizenship privilege, or the positional power to carry out harm, like a landlord abusing their power over a tenant. So I just want us to take in these parallels that exist between state violence and interpersonal violence, because it's often not a framework that we utilize in really understanding intimate harm. It's often reduced to harm between two individuals, and the larger context of where and how these dynamics show up and the parallels between state violence are often overlooked. But when we look at when we look at some institutional responses to survivors, we can identify things like, threats by DCF to remove children unless the survivor complies with the agency's request to do X, Y, or Z. We sometimes see the prevalence of sexual assault or other forms of harm carried out by police officers. We see the use of solitary confinement. as a tactic of control by correction officers, and of course, the sheer force of police brutality. And we understand and we can see some of these parallels between intimate harm and how it is reinforced and replicated by state violence. So the larger narrative of there's a single story that can happen about intimate harm, where we hear so often that it's about men's violence against women, that perhaps it's about sexism as the root cause, but really it's important that we look at the broader root cause as all forms of oppression in this context. So, okay, so now's the history lesson. And again, partly I want to take us through this journey of the history of the anti-violence movement, because there's the single story that we have often been exposed to is one that does look at some major institutional gaps and protections for survivors and all of the efforts to remedy that, especially in the legal context. And that said, there is a broader story to what was imagined, what was identified as the problem, and the solutions that were actually that were proposed and ultimately landed on as the primary strategy. So when we approach the 1960s and 70s, we have a time period where second wave feminism is alive and well, it's emerging. And as part of this movement, there's really a growing demand to address what was largely silenced until then, the realities of domestic violence and sexual assault that were so rampant in the lives of primarily women and girls in the focal point of that era. And there weren't protections for survivors at that time, not really. Institutional support was largely absent. There were laws that still required a divorcing spouse to show that they were subject to more than a permissible amount of physical abuse in their marriage to obtain a fault-based divorce. Severe domestic violence was often met with indifference from law enforcement. Survivors were not believed, right? And that's not a 60s or 70s problem. That's a today problem as well. Shelters were often the rooms that people opened up to survivors in their own houses. Hotlines were, as my old mentor had shared, was a closet in a room that everyone staffed, right? And it's one phone. And they were really, these systems of support were held informally among trusted community members. They were the aunties, the sisters, the neighbors who would take care of each other. So the early years of this movement were oriented not so much around a desire for more policing, but really around more services like helping survivors obtain housing, employment, health benefits. And there was also, of course, a parallel desire to see those who caused harm being held accountable for that harm, and a genuine desire to be taken seriously by those who are charged with being present to protect lifelines. And on the sexual assault front, a similar story was unfolding as well, because, through most of US history, rape was considered a crime of property with no rights afforded to survivors. Those injustices continued far longer and still do for many survivors of color. So the demands of the anti-sexual assault movement, like the battered women's movement, had many similarities, and it was really to recognize sexual harm as violence. And it was to provide some survivors the support they needed to heal. So it's really to hold those who cause harm accountable in some tangible and effective way. And throughout this, there was a desire to have this kind of harm recognized by government to allow for the creation of more resources out of what had been happening so informally for generations before. There were efforts to end sexual and domestic violence, that there was a demand that there be a government response, but not so much agreement in how or to what extent. So in 1984, the Family Violence Prevention and Services Act was passed as the first federal stream of funding to specifically resource domestic violence shelters and programs. And this was a positive step that really resourced communities It would create an infusion of state dollars into the work and had huge benefits for many programs. But throughout this conversation, one concern that many organizers of color had was a growing focus on criminalization as the primary push in the domestic violence movement. The field was beginning to push a pro-arrest agenda. And this really dovetailed with the tough on crime sentiments that were escalating in a national conversation. And of course, these conversations were deeply intertwined with racist narratives that place Black and Brown and low-income communities as the primary target. And so despite the warnings of many, many organizers and leaders of color, at the time, policing became the focus. So there were class action lawsuits against police and prosecutors for their failure to recognize domestic violence. And, really the field rode the coattails of the tough on crime movement. And by the mid-80s, law enforcement was really the centerpiece of battered women's activism. Similarly, on the sexual assault advocacy side, the focus was really recognizing crimes of sexual violence, demanding that police increase their arrest rates. There was privacy for survivors in emergency rooms, judicial training on sexual violence, and changes in how sexual assault crimes were prosecuted, really with an emphasis on conviction. So with partnerships between law enforcement growing, and especially with domestic violence and sexual assault programs, what happened was money began to really change the dynamics. And as our country as a whole invested more in mass incarceration of low-income communities of color, some of those dollars began to go to programs serving survivors of sexual assault and domestic violence. And I want to talk about VAWA and its origins. VAWA is huge for so many of us in this field. And it's important to understand and unpack the history of that. So in 1994, the then Senator Biden asked counsel for something for women in his crime bill. Was something on women. And VAWA was originally really designed to inflate the criminal legal system's response to various forms of intimate harm. And really, it's stayed that course since that time. VAWA was celebrated as a huge victory for survivors, really in the recognition of sexual assault, domestic violence, and other forms of intimate harm as crimes and as demanding and deserving recognition. And it was really what a huge portion of this field was clamoring for many years. And yet there were aspects of this law that, we can certainly celebrate. So many more resources to programs, so much further opportunities to resource other forms of relief. We'll talk a little bit about immigration relief as well. But at its core, Professor Lee Goodmark says one of VAWA's greatest achievements was ensuring that criminalization is a primary response to intimate partner violence in the United States. So it's that fact that really defined intimacy through a criminal legal lens, and it's important to note though. The larger bill carried many harmful components, fueled by fears of super predators. It increased the number of crimes subject to the death penalty. It poured $1 billion to construct prisons and incentivized the adoption of mandatory minimums. So, here we are at this intersection of a larger crime bill that was really fueled by a desire to target those impacted by the ravages of crack cocaine in that time, to target communities of color, and some massive expansion of benefits and support for survivors in very vulnerable scenarios. There were so many more partnerships that were launched between law enforcement and DVSA programs during this time. And Mimi Kim calls this phenomenon the carceral creep. What she describes is a trajectory of a movement that sort of went from a genuine distrust of or desire for change, but sense of distrust and betrayal from law enforcement, to some hopeful partnerships and shared resources So then a move towards the dominance of the values and practices of law enforcement entities into our own field. So it's sort of a swallowing up of a movement-based set of community organizers and programs, towards a much more carceral framework. I'm going to jump ahead a bit. Really, in 1994, I just want to note that about 62% of VAWA funding was dedicated to criminal legal systems, and by 2013, it was about 85%. So that number has increased, and we've seen in the last reauthorization of VAWA definitely some shifts towards more culturally specific program funding, perhaps pilots around restorative justice, LGBTQ specific funding. So all of that needs to be held as a large both and about what this bill really did and continues to be. And I don't want to oversimplify what it means to demand accountability from state systems. In 1998, I was an intern at the Women's Law Project in Philadelphia, and there was a story there that was breaking about the failure on the part of the Philadelphia police to investigate crimes of rape and sexual assault. And it was a discovery that there were many backlog reports and other evidence that were largely associated with the rapes of women of color, of sex workers, and others, where the sex crimes unit has essentially just dismissed or downgraded those rapes into non-criminal offenses because they didn't believe the survivors or didn't believe that they were raped. And at that time, simultaneously, a white Wharton student was killed by her rapist. This is what really brought this larger backlog into life. And so here we are amidst institutional racism, classism, questions of credibility. The demand for police accountability in these contexts certainly makes sense. But there's some ongoing questions to consider. What would have happened if VAWA had been Health and Human Services bill? What would that have looked like? Folks have asked, would this have looked like universal basic income for survivors? Would it have, Mimi Kim says, would it have looked like, mandatory housing or supportive housing? Law enforcement accountability is one aspect, but not the whole. So, this is a bit of the walk through the history of this field, and really a constant tension between celebration of so many of the wins that survivor advocates have been seeking for so many years, but also a kind of an overshadowing of the other stories, who these responses didn't work for, who was left out. What were the stories of advocates of color, survivors of color, queer and trans survivors, survivors who had criminal histories of their own, who were left out of some of the supportive services that were ushered into existence? So it was really during this time period that I, with all of this kind of swirling around us, I come into this work primarily in the early 2000s into law school with all of these conversations swirling around me, some of which I was keyed into, some not. And I knew very much that at that time, I wanted to dedicate my career to working on issues related to gender-based violence. I knew by then that I didn't want to practice family law because I wasn't interested in the specifics of only staying in that space of interpersonal violence. But I knew that where I was most interested in wanting to be effective was at that intersection of both supporting survivors of gender-based violence, but also supporting survivors navigating state violence at the same time. So that's how I came into immigration work, really. Looking at working with survivors who were either seeking protection from the Department of Homeland Security or facing removal by the Department of Homeland Security, sometimes at the same time. So that's where I jumped into the worlds of working with survivors whose narratives of survival were more complex. They were on the line as between someone who was being prosecuted, but also simultaneously seeking support and protection as a result of their own victimization. So this world of criminalized survivors became sort of an ongoing theme in my own work throughout my career. I was really inspired by the immigrant advocates who had secured some essential protections under the Violence Against Women Act. This is this place where these spaces become complex. They become so filled with the both and of what it means to have institutional support for various programs, and also the potential unintended consequences for broader communities. You know, immigrant advocates got to the right tables. We had VAWA protections that were crafted by and for immigrant survivors, and that was tremendously meaningful for countless survivors to this day. So, you know, my own journey, you know, I worked with in the direct service capacity for about 15 years, working with immigrant survivors, and then I moved into the policy field. Moving into the policy field came with a lot of and many questions. I knew I was exhausted by a system that was increasingly abusive to survivors. But I also had a lot of ambivalence moving into a policy sphere and potentially feeling a lot more disconnected from what survivors actually experience every day. Could policy actually be informed by those most impacted? I wasn't sure, but I made the leap and I joined our state coalition. And this was January of 2020, just a few short weeks before shutdown. And this, to me, this period of time really kind of paves the way for so many of our other forms of policy work ahead, because what happened was, you know, it ground us to a halt, shutdown ground us to a halt, and it forced us to confront so many of these questions of, you know, who was our field serving with the rising up in 2020. We had to ask the questions of our own field's complicity in continuing to reinforce laws and policies that would, you know, focus on mass incarceration. You know, what is our relationship to anti-Blackness in our culture? What is our relationship to furthering and reinforcing a system that prioritizes criminalization at the expense of other forms of community support? So, you know, this was a time period where we're all glued to our Zoom screens, and it was really kind of a coming together in some ways of so much of those voices that for so long, throughout that long history that I shared, who were kind of sounding the warning bells of why is this field focusing so heavily on criminalization as a primary response, and we look at what else is possible. That veil thinned. And we were hearing suddenly from so many of these movement leaders that have been for so many years distanced from this field as a whole. So we were sitting with thinkers like Mimi Kim, Sujata Balaga, so many others who were talking with us about how we could craft a new way forward in the field and sexual assaults and domestic violence. You know, what was our collective work to transform our approaches to harm? What do we need to do to increase freedom and wellness and thriving in our communities? So as we listened, what was happening was a renewed centering of the needs of survivors who are most vulnerable to state violence. We started talking about what it means to center the realities and needs of Black survivors, of trans survivors, of immigrant survivors, with the philosophy of when we look to build solutions and systems that can really support and address the needs of all survivors, and we all. You know, of course, we know that that openness has shifted over the past few years, and urgency continues. The return to normalcy continues, and we push towards that. And we can continue to ask the questions of, you know, what is that normal that we want to return to? The coalition space, to me, is situated in such a critical role of being able to craft the thought leadership necessary to inflate healing and community-centered responses, and to really deflate some of our historic over-reliance on criminal legal systems. So I want to talk about what that looks like in practice and really move to some of the emerging policy arenas that we are currently engaged in. Throughout all of this history, I sit in a space where I'm always 1 foot in systems and 1 foot in imagining what else is possible. Because the structures that do exist, and when we stay in this inside game in many ways, we have access to institutions like courts, like law enforcement, legislature, DCF, and other agencies where we can influence what it means to reduce harm in those spaces, while also avoiding kind of overemphasizing their some of the very structures that can create that kind of harm. So it's a complex dance, and we get it wrong sometimes, but we do our best in this. At the end of the day, this field is too powerful to walk away from. And as an advocate that I'm fond of saying, as we were talking about critiques of criminal legal systems, she said, well, those systems are, I agree, those systems are bad enough, but I can only imagine the experiences for survivors, especially survivors who are of color or other marginalized survivors. If we were not in those rooms, what would happen? So when talking about this idea of stewarding the long arc, what we do at JDI is take an intersectional approach to our policy framework, because we know that work to improve the lives of survivors has to be intertwined with efforts to advance economic justice, racial equity, human rights, education and prevention, and access to safety and justice for all survivors. So we do this with holding that intersection is really our path forward in our policy demands. We can demand accountability from systems, and we also don't need to widen the net where those systems can cause harm. So briefly, to leave enough time for questions, I want to talk about 3 areas of policy direction that we're currently involved with. First is the huge win we had last session, which was the passage of protections related to coercive control and the non-consensual sharing of intimate images. For folks who know civil protection orders, they're sometimes called restraining orders, or in Massachusetts, they're 209A orders. They're a powerful tool of protection for many survivors. They are a way in which they are survivor directed. The survivor gets to choose when and whether to request such an order. And they get to tell their stories. And judges can order a person who's caused harm to stay away from a survivor's home or their workplace, and much more. And so they're a civil remedy and only carry criminal consequences if violated. And sometimes these are dismissed as it's just a piece of paper. But honestly, in my experience as a practitioner, they go such a long way in increasing a survivor's own sense of safety. And most survivors who receive protection orders do find them to be effective. Until this past fall, this protection was only available to survivors who were able to show that they had actually experienced physical harm or a fear of imminent physical harm. And so the conversation arose, well, what about all else that happens in the dynamics of domestic violence and sexual assault? What about an individual who's living under constant surveillance, maybe isolated from their friends or cultural community? What happens when they are being surveilled, gaslit at every turn, and they see and understand their own experience as intimate partner abuse, but they're told by a court that they don't qualify because their experiences don't meet the definition of abuse. So this past session, we became the 7th state to expand our definition of domestic abuse to include coercive control as a form of protection, a basis for eligibility for a protection order. So this is a form of abuse where perpetrators use threats, intimidation, isolation, stalking to maintain power and control. The law also contains some necessary protections to curtail the use of the non-consensual sharing of intimate images. So I just want to say that this picture really emerged from the demands of survivors and advocates who wanted to see laws reflect their own experiences and what we know is true about domestic violence, that this isn't just about physical harm. but that survivors' experiences need to be at the core of the remedies that are available to them. And, this is a case study in organizing. Something went through the Massachusetts legislature in one session, which is shocking. And, it was a coalition, survivor-led coalition that really, really deserves the credit for making this happen. And it was Together Rising Above Coercion that did that. So that was one example of a survivor-driven and led advocacy effort. I'm gonna run through two more, and then I'm gonna give you a few minutes for questions. Another area when we talk about what does it mean to create policy practices that are at all holding the words collective liberation and policy sometimes can feel painfully inadequate, and yet. We look at questions like economic security in this time. What are the things that we have within our own control and in our own state that we can do to advance policies and practices that make our communities and the lives of survivors better? For survivors to be able to find economic stability, it's really it changes the landscape of their ability to survive and thrive. And when we look at what is available in Massachusetts, we see a lot of need for reform in our victims' compensation programs. But through that, so we're doing some concerted effort to reduce some of the red tape of our victims' compensation programs. But we're also, and the piece I want to highlight today is looking at what else is possible in terms of compensation for survivors who experienced harm. What would it mean to expand the possibility of direct, flexible cash assistance to survivors? We know that during the pandemic, there were many, many experiments that moved and served to reallocate funds into the hands of survivors, and they worked. There's a lot of stories about, was there fraud? Was there this? At the end of the day, those programs worked well. And so redirecting resources into the hands of survivors when they're most vulnerable, it can directly be credited to better outcomes in survivor safety and healing and stability. So that's what we're doing. We're creating a flexible funding program for survivors, and we've filed this piece of legislation that will be available to the Community Advisory Board that will hopefully, if passed in 1 to 10 sessions in Massachusetts, will allow survivors to be able to receive direct flexible cash assistance on their own. Norma Wong does state that in this moment, this work of being able to secure resources from those in power and reallocate resources towards community needs is one of the single most important strategy shifts that we can be engaging in as a community, and it's tangible. We have access and power to do this. Very quickly, finally, and I'll talk more about this at the panel on next week if you join. But we're also looking at passing the Domestic Violence Survivor Justice Act, or Domestic and Sexual Violence Survivor Justice Act here in Massachusetts. And that's really offering an opportunity for survivors who have themselves been criminalized because of the things that they have done to survive. An opportunity to have a second look at their sentences, or have their conviction looked at even pretrial, and to take a look at and transform our culture and instinct to incarcerate, and instead really infuse those conversations with an understanding of impact of domestic violence and sexual assault on people's lives. So we're really looking to kind of shift away from this narrative of perfect survivors, which are so harmful in our culture, and move towards these kinds of policy solutions that will hopefully transform the lives of a lot of us. Next week I'll talk a bit about the prevalence of the reality is 94% of survivors in prison, of women in prison, have experienced domestic violence and sexual assault. So we need to be holding that reality as we're looking at the impact of our criminal legal system responses in this context. So these are just a few windows into what it means to move in a policy strategy direction that does begin to center communities and center our collective ability to thrive. And move us a bit more towards our own sustainability, both as a field and as communities. And so, all of us are part of this challenge. We're all going to have to answer the questions of how we're going to be able to advocate on behalf of communities who are increasingly unwell in these coming months and years. And what it's going to take to keep us well and to continue to support communities in that journey. And so, I think it's going to take a lot of courage and relationship building and strategy building. And, we all have the capacity to make this change. And I just want to close with some of the words that have continued to circle back and inspire me. And this is words by Octavia Butler, she says, all that you touch, you change. All that you change, changes you. The only lasting truth is change. And she goes on to say, change is God. And so Octavia Butler, let's continue to build upon her words to us and use our power to create change.
First of all, thank you to Professor Kempster for that wonderful introduction. My name is Amanda Teo. I use she, her pronouns. I'm deeply thrilled to be here in community with Hema today. We are, if you think the time is fast, it's not just because Hema's speech was so gripping. It is actually that clock is fast, so we have a couple minutes. I do want to open up the floor for one question with the caveat that there's going to be lots of opportunities to engage with Hema this week. And then I invite you to please make time on her schedule to meet with her one-on-one. So I'm going to take one question. It should be a really great one. I'm sure it will be. Anyone have anything? Back up. Hello, it's a pleasure to hear you speak. And I'm like a feminist, and it's really hard to say a lot of the things that you've been saying in like a compassionate and feminist way. So I want to thank you. And I'm just Virginia. So one thing that I've encountered in my limited exposure to working in with the intimate partner violence legal setting is, and just in like law school in general, is this whole discourse about trauma and like how it affects like people's like actions, like their whole demeanor, obviously the course of their lives, their well-being, and I think often in like the legal settings, like there's this idea that like we know like, oh, they're experiencing trauma, so that kind of taints their ability to be like their normal self, and to like make the decisions that maybe they would be able to make if they hadn't had this thing happen to them. So I guess I just was wondering about the whole like autonomy question. Also just, there's so many like tactical decisions that survivors have to make in order to access like immigration benefits or legal services, or like public benefits, or in order to like keep their children and other things. So I guess I just wanted to know, how do you think it's best to, like let people have autonomy and like empower them at the same time, because so much of this empowering stuff, like I worked on like a civil protection order case, and like the lawyer was pushing me to do it and the client didn't even really seem to want it, and that like really turned me off like the whole family law thing. So yeah, I'd love to hear your thoughts. Thank you.
No, that's a great question. I mean, I think that is I think there's a few pieces. I mean, we can learn a lot from the frameworks of I'm thinking a lot about universal design principles and human-centered design principles across the board. And it's, I don't feel like we talk about that a lot in the legal context, right? Because we're set up as experts in a particular body of work. And then, of course, in the DBSA survivor representation context, we are also then simultaneously taught to practice this kind of trauma-informed type of lawyering approach, and they can come into conflict a lot. It can feel like it comes into conflict. I'm a firm believer that survivors are experts in their own experience, and especially around the safety decision, because when you work with survivors long enough, the minute by minute decision making that is happening and the triaging and understanding of when and whether and what is safe or not, it is the air that survivors breathe. And so remembering that level of executive function that an individual is engaging at all times is really critical in that piece of it. I think that there's also there can be a both and to this, right? We hold information and we are oftentimes translators, and that help supporting survivors navigating complex systems that honestly are, regardless of one's trauma history, those systems are challenging. I'm sure the first time any of you all sat in a court felt that way, right? It felt deeply intimidating to be in that kind of setting. So I think we can balance, and I'd love to have a longer conversation with the three that jump in, to balance this, our role and right size our role as information providers, as you know, we can tear away some of the veils of this system and name when we see systems as being potentially courts or other settings as potentially that are going to re-traumatize. It's fine, but we should and can have an obligation to name them, while also really closely listening to what a survivor's needs are in a particular context. What are their safety go-tos in their community? Everybody has the sense of survivors as isolated, and that is true in many ways. And also, I think what is often overlooked and sometimes in our work is the many, many resources that survivors do engage with every single day. There's often an entire world of strategies that a survivor is engaged in, with whether it's about particular individuals who are supportive along the way. You know, one of our conference calls it, pod mapping, like who's in the network of that individual, and what are the safety possibilities that do exist, and is something like a civil protection order something that would be supportive of that or not, right? Those are the kinds of conversations we can have, always leading from the survivor. What are their goals in that moment? What do they want to see for their own life and in the immediate or longer term?
Thank you for that question. Thank you for that answer. Emma, you inspired me from the first minute of your presentation when you said, what we're here to do is to build the world we want to see. And I think a lot about one of my graduate school colleagues, Professor Sophia, who published an essay about her survival and sexual violence. And in that essay, she talks, which is called The Refuge for Jane Doe. She said, there are many ways in which this world is not ideal. And then she ends with this. She said, yet I believe in the reality of ideal worlds. They can be articulated, they can be drawn, they can be painted, they can be diagrammed, they can be mediated, and they can be realized. And that structure, like grammatical structure of the can be, that possibility that is inherent in that construction, that is what I was so thrilled with today, listening to you and this community with us. So Hema, on behalf of the BC community and the Rappaport Foundation, I want to thank you for teaching us what we could be doing to make this world what it should be, what it can be, what it must be. And I want to thank you for just the first of two panels that two events you're going to be doing on our behalf this next week. And I want to invite everybody here and online to join us for our next presentation, which is going to be a panel discussion this time next week on emerging issues in DBSA advocacy. So thank you, Hema. Please give her a round of applause.